Going on the record for this? Looks like we are.
Yeah, I guess.
Would you like me to call the case, Your Honor?
Yes, please, Mr. Johnson.
We are here in the matter of the State of Oregon versus Benjamin Smith. This is 22 CR 08677, Nathan Vasquez and Ms. Muriel Mota, representing the District Attorney's Office in the State of Oregon. For the record, my bar number is 014437. I'll let Ms. Mota introduce herself.
It's Muriel Mota, MOTA, bar number 155189. Good afternoon, Your Honor.
Good afternoon, folks.
Good afternoon, Your Honor. John Sarr for Mr. Smith, SARRE 034434 is my bar number. And Mr. Smith, as the court is probably aware, is not here today. He was transported to OHSU, I believe, although I can say that he's not on the jail roster as of this afternoon.
So he had a medical issue that required him to be hospitalized?
Yes, that is my, well, Judge, that was my understanding the last time Mr. Smith was hospitalized a couple weeks ago when we were supposed to have, I think, the same hearing and had to move it to today's date. The jail does not tell me when these things happen, so I can't say, but that's what I assume, though, that he had another medical issue. He does have ongoing issues that do need essentially constant medical care. So that's my assumption, is that there was another issue, and the sheriff's office transported him to the hospital.
Okay. I just wanted to touch bases with counsel. Even though I know Mr. Smith couldn't be here today because of his medical situation, I don't want to make any decisions, but I just want to kind of see where we're at on a couple of procedural issues. So, Mr. Sarr, do you know, from talking to your client, because I assume you've been able to consult with him, do you know whether you'll be requesting a bail hearing, whether you'll be waiving 60 days? Do you have any sense on those sort of preliminary issues that we need to deal with here?
Well, Judge, for one thing, I'm still going through discovery here. I was provided with about 5,000 pages of 5,500 to be more exact, pages of discovery. I'm still going through that. But more to the court's question, Mr. Smith is not, while there may be a bail hearing, I don't think it's going to be necessary to schedule a bail hearing within 60 days. My client and I have talked about that. He certainly didn't preclude having a bail hearing. I don't think it's going to be an immediate thing to schedule, but we did discuss the waiver. While I don't have a waiver today, as you know, it's been difficult to get access to Mr. Smith because of the back and forth with the hospital. I do believe he'll be agreeable to signing one when I can actually meet up with him in person and do that.
Okay. And if he changes his mind on that, do you anticipate requesting a good cause extension?
I think the court could find good cause because of Mr. Smith's medical issues.
Although I don't really see that in the statute.
Well,
but obviously, if the defense counsel can't reasonably be ready for trial, I can find good cause.
Yes, and I guess I don't want to speak out of turn on that.
Okay.
That I think my client needs to give me his take on that after I explain that to him. I did, as I said, I did discuss the bail hearing. I don't feel that he's necessarily wanting to even go through the process altogether, but I don't want to close the door on it at the same time. But I don't think there will be a major disagreement with Mr. Smith and myself if I were to ask the court to do that, or I don't have the statute in front of me at the moment, but it seems like this is a situation where the defendant is not in a posture that we can even have the bail hearing if he's not available.
Yeah, it was interesting how the statute talks about how the 60 days shall toll during the time period a defendant
is at the hospital and things like that.
Well, no, it talks, I thought it says it can toll during the time period we're dealing with capacity, like aiding and assisting.
Right. When I said the hospital, I meant the state hospital.
The state hospital, yeah. Or if there's complex scientific issues, victims can't be available. There's a variety of things. But right, any reasonable delay resulting from examination or hearing regarding the defendant's mental condition or competency, but not physical condition. But of course, one way we extend 60 days on a regular basis is if if counsel is unable to try the case within the 60-day period, or that the attorney cannot reasonably be ready for trial within 60 days. Okay, so I understand your position at this point, Mr. Saar. What's the state's request in terms of setting a trial date? I mean, normally if 60 days have been waived or if a bail hearing's been had and the person was, and the state met its burden under the bail hearing statute, you know, we'll sometimes delay in setting the trial date. I'm curious if you want to set one sooner rather than later.
My preference would be to first deal with the bail hearing matter and just as a maybe set status hearing, whether that's in 2 weeks, and have the state's strong preference is to have a written waiver by the defendant. I understand that the way the statute's written, and sometimes we can look to find good cause in other ways, but the statute, the way it's written, the safest route is with a waiver by the defendant. It sounds like that is something that should be able to be accomplished. Okay. And then once we have that in hand, and if there's not an immediate like, hey, we're going to have a bail hearing in a month, then I think at that hearing we could set trial dates and kind of get that process going.
Okay. Do you feel like you've been able to provide discovery to the defendant, and at least in terms of what you have so far?
Yes, we've turned over everything we've had, and a lot of what I know Mr. Starr is probably kind of wading through is medical records. There's extensive medical records that have been turned over, and that's a lot of the pages. But as far as police reports, video evidence, other photographic evidence, that's all been turned over as far as I know, that anything that we have should all be in defense's hands at this time. Okay,
great. All right, 2 weeks, Mr. Starr, does that sound right to you?
2 weeks would be fine, Judge.
I know next week we are really busy.
2 weeks. You are still in start court the mornings.
Can we find a 1:15 sometime?
There should be plenty of time.
Yeah, there's just not a docket in there that I can fill in. But the 25th, there's the Monday, April 25th. We have full availability all afternoon.
And we're doing start court that week, so we won't go to trial.
You're doing step court that morning. You're doing start and it looks like step court the Monday morning.
So we won't get trial, Judge. No, those 2 weeks are completely.
So we could do 1:15 on the 25th?
We can, Judge, yes.
How about the 25th, folks?
I can change the session.
Okay, perfect.
Judge, is it possible to do another day that week? I may have family in town. I think they might be gone by the afternoon, but I'm not sure. I'm going to have to take some to the airport.
We can do any of these days.
Yeah, there's just no docket.
It's okay.
Any of which days?
The 26th, 27th, 28th, or 29th. There's
1:15, any of those days.
Okay, so I guess 1:15 anytime that week. What do you guys want?
That's fine with the state, either of those.
Mr. Sarr, what do you care?
I don't, other than the 25th that's the bad one.
That's the Monday?
That would be the Monday.
Why don't we do Wednesday?
Wednesday? Okay.
At 1:15.
I'll have to create a session.
Yeah.
Is that the 20th, Your Honor?
That would be the 27th.
Sorry, the 27th.
Yeah.
At 1:15.
I'll go open up the courtroom.
Thank you,
Thank
Mr.
you, Bruce.
Rucker.
And Judge, while assuming Mr. Smith is back in the custody of the sheriff, would the court allow him to appear by video for this hearing if it's not going to be something? It's going to be something fairly quick. Mr. Smith cannot walk. He cannot really sit for long periods of time right now. He cannot get out of bed without assistance, so I think transporting him is going to be a logistical difficulty. So
Yeah. I tell you what, Mr. Sarr, if he would prefer not to be transported because of his medical condition, we can maybe have him appear by video. I don't think they have much video capability over at. Is he at? He's not at Inverness. He's
he's
here.
at Inverness, actually.
Oh, he
Judge,
is.
surprisingly enough.
We've done a video conference with Inverness before.
We have.
I just don't know how capable they'd be to set him up if he can't make it to the.
Well, it'd probably be easier than bringing him here.
Yeah.
Sure. Would you just be in touch with Mr. Walker on that?
Of course.
And then we'll try to make that work.
Yeah.
Okay.
Your Honor, will the court still be in this courtroom or?
No, I just have a civil trial with stacks of stuff on the desk next door. So
You've got a crowd over there.
yeah, there's a crowd over there.
Yeah.
Is that 17C is the normal courtroom?
B.
B. Thank
Yeah, I'm actually going to be in this courtroom when we do there's going to be a courtroom shuffle coming up in a few weeks. I'm not sure. Have you heard when that is?
They've given out a couple dates, and I don't think they have a firm.
Yeah, so at some point
right.
in the next month, probably, I'll start being in this courtroom permanently. So,
In order for rescheduling.
but I think in 2 weeks we'll be in B still.